The question always comes up, what is the minimum asset or net worth that an individual or a family must have before they consider implementing a domestic asset protection trust? My personal opinion is it starts at about $2 million and goes upward from there, although there are occasions when it could be less than $2 million if the individual's in a particularly high risk industry and has some money, if not a great deal of money, in the bank, but anticipates a great deal more money in the near future. The additional factors that you need to consider as to whether or not you should get into an asset protection trust is, first and foremost, are you in a high-risk business or profession? My own personal opinion is that any entrepreneur is in a high-risk business. At any point in time, you could lose everything. It could be a change in the economy. There could be some catastrophic event. It could be a divorce. It could be any one of a number of things that happen to you in the general course of your life that would upend your business. Specifically, I'll give the example of a divorce. If a family has entered into an asset protection trust as a part of a estate plan in order to protect the continuity of that family, then the divorcing spouses will not be able to split that trust up in the underlying assets between themselves and wreck the financial well-being of that family. In other instances, if it's a single individual, if you're in a high-risk business or anticipating getting married in the near future, a domestic asset protection trust in that instance would be the best prenuptial agreement that you could ever get into. It's recognized specifically by 36 separate states. The other 14, to my knowledge, just simply haven't considered them yet. In fact, I've recently been apprised of 2 decisions in New York and 1 decision in New Jersey that recognized the Wyoming Domestic Asset Protection Trust as having vitality in divorce proceedings in those states. The interesting thing about an asset protection trust is that the entirety of the family is protected by that trust. So when you get into a family business and the husband and wife or the grandfather, grandmother, or any of the kids get a divorce, then that divorce is not going to have an impact on the assets within that trust. Now, a court considering alimony would not be able to consider the assets within that trust as a part of the divorce estate. The divorce court, however, would be able to consider distributions from that trust, if any, that come to one of the divorcing participants as a key factor in child support and alimony. Mark Twain has a saying, "It's not what you don't know that will hurt you, it's what you do know that just ain't so." So what ends up being a problem for many individuals as they go through life is that they are ambushed by factors they would never have considered. And for that reason, my feeling is that as an individual, everyone should be in an asset protection trust if they have a significant amount of wealth that needs to be protected against those unforeseen circumstances. So we focus a lot on individuals who are in professions and businesses that are high risk. But it would seem to me, after having been in the bankruptcy field for over 10 years in Colorado during the crash of 1980, that every business is a high-risk business if you give it enough time. Generally, what I run into is one of procrastination. People have a tendency to put off getting into a trust until the time that they think that they need it. The problem is, under the law, is that if you are planning for a future event, you're well within the ambit of the law and the efficacy of the protection that comes from an asset protection trust. The difficulty is that when a situation arises where you need that asset protection trust, you're not planning any longer, you're reacting. What we get across is something that has been going on within the evolution of the practice of law and the statutes within the asset protection trust field that provide an estate planning mechanism for families. That mechanism needs to be put into place to protect those families. If it's a part of a estate planning ideal, then it's perfect. You're not reacting to anything. If something comes up in the future, you did this for the benefit of your family and the transition of that estate down through the generations of your family. If you did it in reaction to a difficulty that you had, your creditors and the bankruptcy courts and the judges are going to pick you apart. So it's important to plan, and the best time to plan is when you don't have an exigency facing you. It's called the Voidable Preferences Act or the Fraudulent Transfer Act. You've got one in every state. It's gone through various permutations over the years, but essentially what it comes down to is you have an existing creditor who is hurt by a transfer. They can pull that transfer back out of the trust, liquidate that asset, and leave you with nothing. So the important thing to remember is the best time to plan is when you're planning, not reacting. If you fit the criteria for entering into an asset protection trust and you're on the fence, the only thing I can ask you is, what would it take to get you off that fence? A bat? Because your creditors have a bat and they're willing to use it if they need to. So you need to act while you can act. Why wait? Why procrastinate? You didn't procrastinate getting into the position of accumulating the wealth that you have. Why would you get into the position of procrastinating to keep the wealth that you have? Don't wait. book a consultation. The link is in the description below. My name is Mark Pierce. I was a CPA prior to becoming an attorney, and I've been an attorney now for 44 years. I have been working a lifetime helping individuals and their families preserve and protect their wealth. Thank you for watching. Stay tuned for the next video.